The United States Supreme Court has declined a bid by Republican lawmakers in the eastern U.S. state of North Carolina to revive a state law requiring voters to present identification at polling places. The state's Republican-controlled legislature passed the law in 2013 with advocates saying new measures that also eliminated same-day voter registration and reducing the number of days for early voting were necessary to prevent voter fraud. But opponents, which include rights groups and Democrats, say those steps unfairly target African American and Hispanic voters who are less likely to have a photo ID or have easy access to polling places on Election Day. An initial federal court decision rejected those concerns, but on appeal the Fourth Circuit Court of Appeals said the legislature passed the law with discriminatory intent. The Fourth Circuit opinion cited research done by the lawmakers before crafting the law, saying they requested data broken down by race on the use of different voting practices. Although the new provisions target African Americans with almost surgical precision, they constitute inept remedies for the problems assertedly justifying them and, in fact, impose cures for problems that did not exist, the court said. North Carolina's then-governor asked the Supreme Court to reverse the decision, but when a new Democratic governor took office in January, he and his attorney general asked the court to dismiss the case. Republican leaders in the legislature subsequently asked that they be allowed to represent the state against those challenging the law. Supreme Court Chief Justice John Roberts cited the confusion in his two-page notice denying the appeal Monday, and specified that the court declining to hear the case was not a statement on the legal merits. Governor Roy Cooper welcomed the decision as good news for the state. "We need to be making it easier to vote, not harder," Cooper said. "I will continue to work to protect the right of every legal, registered North Carolinian to participate in our democratic process." State House Speaker Tim Moore and Senate Leader Phil Berger issued a joint statement saying those who want stricter voter ID measures have been denied their day in court. All North Carolinians can rest assured that Republican legislators will continue fighting to protect the integrity of our elections by implementing the common sense requirement to show a photo ID when we vote, the statement said. Currently 32 of the 50 U.S. states have a law requiring or requesting voters show some type of identification before they are allowed to vote, according to the National Conference of State Legislatures. The Supreme Court could be asked to consider another case regarding the issue in the near future, as a legal challenge against a voter ID law in the southern state of Texas moves through the court system. The Supreme Court is letting stand a lower court opinion from last summer that struck down North Carolina's voter ID law. The law was challenged by civil rights groups and the Obama administration, which argued that the law's photo ID requirement had a disparate impact on minority voters. The North Carolina General Assembly had urged the court to review a lower court decision that held the law targeted African Americans with almost surgical precision. The Supreme Court declined to weigh in, but Chief Justice John Roberts wrote separately to stress that the denial should not be read as an endorsement of the lower court's decision. The case was complicated by the fact that after the election, North Carolina's new governor, Democrat Roy Cooper, moved to dismiss the appeal that was first filed when Republican Pat McCreary was governor, while lawyers for the General Assembly urged the court to move forward. Given the blizzard of filings over who is and who is not authorized to seek review in the court under North Carolina law, it is important to recall our frequent admonition that the denial of writ of certiorari imports no expression of opinion on the merits, Roberts wrote in a statement. It would have taken 4 justices to take up the case, but Roberts' separate statement reflects the fact that the court saw a procedural obstacle and will instead likely wait for another similar case to come to the court before giving any more guidance on the divisive issue of identification for voters at the polls. Last summer, before the election, the justices signaled they were closely divided when they split 4-4 on a request to allow the provision of the law to go into effect for the election. The Supreme Court sought amend provisions of the law, concerning a tightening in voter ID requirements, cutbacks on early voting and the pre-registration of 16-year-olds, remained off the books for November's election. Today's announcement is good news for North Carolina voters, Cooper said in a statement. We need to be making it easier to vote, not harder, and the court found this law sought to discriminate against African American voters with surgical precision. I will continue to work to protect the right of every legal, registered North Carolinian to participate in our democratic process. The North Carolina GOP said in a statement that it plans to continue to fight for the voter ID measures. Republicans will continue to fight for common sense and constitutional voter ID measures, similar to what many other states already have, Chairman Robin Hayes said in a statement. While Governor Cooper and Attorney General Josh Stein have stymied voter ID for now, they will ultimately lose in their efforts to block North Carolina citizens from having these protections. And Republican leaders of the General Assembly, House Speaker Tim Moore and President pro tempore Senator Phil Berger, vowed to continue fighting to protect the integrity of our elections by implementing the common sense requirement to show a photo ID when we vote. The ACLU applauded the Supreme Court's decision to let a lower court opinion stand in a statement Monday. This law, enacted with what the appeals court called discriminatory intent and almost surgical precision targeting African American voters, is meeting its much-deserved demise, Dale Ho, the director of the ACLU's Voting Rights Project, said in a statement. An ugly chapter in voter suppression is finally closing. And Kristen Clark, the president and executive director of the Lawyers Committee for Civil Rights Under Law, said the court's move now renders North Carolina's law null and void, and brings to a close a long and protracted battle over a law deemed one of the most egregious voter suppression measures of its kind. Now is the time for North Carolina lawmakers to restore access to democracy for its citizens, Clark added. Meanwhile, Democratic National Committee Chair Tom Perez called the court's move a huge victory. This is a huge victory for voters and a massive blow to Republicans trying to restrict access to the ballot, especially in communities of color, he said in a statement. Across the country, the GOP has rammed through laws like this one to make it harder, not easier, for Americans to exercise their constitutional right to vote. But the Conservative Heritage Foundation said it was disappointing that the Supreme Court did not accept for review an obviously wrong decision by a Fourth Circuit panel that doesn't follow the court's own precedent and other decisions on voter ID by other federal courts. The Supreme Court on Monday refused to revive a restrictive North Carolina voting law that a federal appeals court had struck down as an unconstitutional effort to target African Americans with almost surgical precision. The court's decision not to hear an appeal in the case effectively overturned one of the most far-reaching attempts by Republicans to counter what they contended, without evidence, was widespread voter fraud in North Carolina. The law rejected the forms of identification used disproportionately by blacks, including IDs issued to government employees, students and people receiving public assistance. Democrats and civil rights groups, wary of the Supreme Court now that it has regained a conservative majority with the appointment of Justice Neil M. Gorsuch, welcomed the announcement that it would not hear the case. An ugly chapter in voter suppression is finally closing, said Dale Ho, director of the ACLU's Voting Rights Project. The leaders of North Carolina's Republican-controlled legislature vowed that they would seek to enact new voting restrictions after their defeat. All North Carolinians can rest assured that Republican legislators will continue fighting to protect the integrity of our elections by implementing the common sense requirement to show a photo ID when we vote, House Speaker Tim Moore and Phil Berger, the president pro tempore of the North Carolina Senate, said in a statement. But their options will be limited by the appeals court decision and will most likely face opposition from Governor Roy Cooper, a Democrat who welcomed the Supreme Court's decision not to hear the appeal. Today's announcement is good news for North Carolina voters, Mr. Cooper said in a statement. We need to be making it easier to vote, not harder. The divisions in the state's leadership, which led to a dispute about who represented the state in the case, figured in the Supreme Court's decision not to hear it. Chief Justice John G. Roberts Jr. wrote in a statement that accompanied the court's one-sentence order. He added that nothing should be read into the court's decision to decline to hear the case. The Supreme Court's action set no precedent and will have no impact in most of the country. But it let stand the United States Court of Appeals for the Fourth Circuit's sweeping rejection of an array of voting restrictions by North Carolina. The law, enacted by the state legislature in 2013, imposed a range of voting restrictions, including the new voter identification requirements. It was part of a wave of voting restrictions enacted after a 5-4 Supreme Court decision that effectively struck down a central part of the Federal Voting Rights Act, weakening federal oversight of voting rights. The case challenging the North Carolina law was brought by civil rights groups and the Obama administration. A trial judge rejected arguments that the law violated the Constitution and what remained of the Voting Rights Act. But a three-judge panel of the appeals court disagreed. The appeals court ruling struck down 5 parts of the law: its voter ID requirements, a rollback of early voting to 10 days from 17, an elimination of same-day registration and of pre-registration of some teenagers, and its ban on counting votes cast in the wrong precinct. The court found that all 5 restrictions disproportionately affected African Americans. The law's voter identification provision, for instance, retained only those types of photo ID disproportionately held by whites and excluded those disproportionately held by African Americans. That was the case, the court said, even though the state had failed to identify even a single individual who has ever been charged with committing in-person voter fraud in North Carolina. But it did find that there was evidence of fraud in absentee voting by mail, a method used disproportionately by white voters. The legislature, however, exempted absentee voting from the photo ID requirement. The court also found that the early voting restrictions had a much larger effect on black voters, who disproportionately used the first 7 days of early voting. The law, the court said, eliminated one of 2 souls to the polls Sundays, when black churches provided rides to polling places. Voting rights advocates had been watching the North Carolina case for signs of how a closely divided Supreme Court would rule on similar lawsuits now that Justice Gorsuch is on the court. In September, a deadlocked Supreme Court turned down an emergency pre-election request from state officials to block the appeals court's ruling. Justices Ruth Bader Ginsburg, Stephen G. Breyer, Sonia Sotomayor and Elena Kagan voted to reject the state's arguments. Chief Justice Roberts and Justices Anthony M. Kennedy, Clarence Thomas and Samuel A. Alito Jr. would have temporarily reinstated parts of the law. The decision on Monday not to hear the case turned on procedural issues, not on the substance of the suit, so the court's current leanings remain unknown. State officials asked the Supreme Court in December to hear their appeal in the case, North Carolina v. North Carolina State Conference of the NAACP, number 16833. 2 months later, in an unusual last-minute procedural maneuver, 2 newly elected Democratic officials, Mr. Cooper and Attorney General Josh Stein, asked the court to dismiss the state's petition seeking review. Lawyers for the General Assembly opposed the motion. In his statement on Monday, Chief Justice Roberts said the Supreme Court's decision to decline to grant the petition seeking review, or petition for certiorari, turned on that dispute. Given the blizzard of filings over who is and who is not authorized to seek review in this court under North Carolina law, the Chief Justice wrote, quoting an earlier decision, "It is important to recall our frequent admonition that the denial of the writ of certiorari imports no expression of opinion upon the merits of the case." Civil liberties advocates, nevertheless, called it a victory for voting rights and, for now, at least, a precedent with broad application. "This is the law of the land in the Fourth Circuit," said Daniel T. Donovan, a lawyer for the plaintiffs. The justices are likely to take a more definitive position on voting rights issues when and if they hear one of several cases that appear bound for the court. The most likely candidate is a lawsuit challenging Texas' 2011 voter identification law. A federal district judge ruled in April that the Texas legislature had intentionally discriminated against Black and Hispanic voters when it enacted the law.